You. All right. Hello, everybody. I'm Dan Downs. I'm Director of Digital Learning in North Reading, and I'm here with Kathy Dashow and Rayma Hawley from the Tech Collaborative. We're here today to talk about data privacy and computer science applications. Kathy and I are part of the MassQ Special Interest Group for Computer Science and STEM. And data privacy is a huge topic in education and ed tech and education in general. And we're excited today to have Rayma talk about her work with tech and also talk about some of the approved data privacy tools that are out there. So thank you, Rayma, for joining us, and look forward to having another great conversation.
Great. Thank you, Dan. As Dan said, I'm Rayma Hawley. I work for the Education Collaborative. It's a public school collaborative located in Walpole, Massachusetts. We have 16 member districts. Many of you probably belong to collaboratives as well. So just a little bit of history about what we do. We're a cooperative, so we work with our member districts to do things together that we can't afford to do or don't have the resources to do separately as districts. And one of the things we identified a couple years ago was student data privacy. None of our districts were doing anything to protect students online. And we quickly realized that we needed to. So we brought in Steve Smith from the Student Data Privacy Consortium. He's also the CIO from Cambridge Public Schools, and he did some PD with our technology directors from our member districts. And we understood that we needed to get data privacy agreements for all the digital tools that we were using that transferred PII to the vendor. So we individually tried to do this as districts, and it was way too much work, and it cost us way too much in legal fees. So we decided to do it together through tech. And the first year we did it, we were about $68,000 in the hole from legal fees. And we really wanted to sustain this work. So we decided to open it up and invite non-member districts around Massachusetts to join us, and we would do the work together and spread the costs. We're a nonprofit. So it was very successful. A lot of districts joined us, and not too long after that, other states started joining us. We have New Hampshire, Rhode Island. We've kind of put the brakes on other states for right now. We can just maintain this work. We don't want to become overwhelmed by other states. So it's just the 3 states right now. But so we hope today that you leave here with an understanding of what privacy requirements are in today's world of digital tools, and that you learn what you need to do and what your district needs to do under state and federal law to protect your students and your student data online. So, let me go back. So I'm just going to quickly go through some of these headlines. People say, well, why is this important? Well, it's been in the headlines a lot. Our student data is very vulnerable out there. People are getting hacked. Data is getting stolen. We really don't want to be using any tools that we know aren't safe. These are just some of the recent headlines about data breaches. So what I always say is you don't want to be the teacher that selected a high-risk tool, brought it into your school, and there was a data breach and all sorts of student data got stolen. You don't want Fox News in your parking lot, talking about this on the nightly news, this big data breach. So there's a lot of laws, state and federal, that protect student data. The one that we're most interested in is FERPA. So FERPA says that you, the school, cannot share student data, and even a student's name or email address is considered student data, with anyone without the parent's permission. And there's a few exceptions to that law. And one exception is the school official exception. And what that says is if you make someone a school official and they have a legitimate educational interest in the student data, you can share the student data with that school official without written parent permission. So that's the vehicle that you need to use to share student data with an online vendor. So how do you make a vendor a school official? The best way to do that is to have the vendor sign a data privacy agreement where they agree in the agreement that yes, they are a school official. So we use the Massachusetts Student Data Privacy Agreement, and it does a lot more than just collect or just protect student data. So it makes the vendor the school official. So now you are compliant with FERPA. You're not going to be in violation. You're not going to get in trouble. It gives you, the school, ownership and control over all the student data that you've given to the vendor. And it defines how that vendor can and cannot use that student data. It also prevents the vendor from targeting ads to the student. They can still advertise with age-appropriate ads, but they cannot target advertise to the students based on their use of the tool. The data privacy agreement gives us the right to audit the vendor. We can say, we want to come to your location, we want to see your data security, whatever we want. We have the right to audit the vendor. It also says that the vendor has to conduct criminal background checks on any employees of theirs that have access to the students through a help function, through email, or even access to the student data. We think this is really important. It sets a minimum threshold for data security requirements. They have to meet this threshold or they cannot sign the DPA. If they do have a breach, they have to notify you within so many hours. We know of situations where tools we've used in the past, they had a security breach or a hack, and we didn't learn about it until we read about it in the paper. So this is really important too. It's also an enforceable agreement between you and the district. So if they don't abide by what's in the data privacy agreement, you can take them to court, you can sue them, you can be awarded damages. And very importantly, the DPA supersedes the vendor's TOS, whether it be a license or a click-through, and their privacy policy. The terms and conditions of the DPA prevail and supersede anything else in writing from the vendor. So people ask, why a data privacy agreement? You know, a lot of these vendors have signed the pledge, they have a keepsake privacy badge, they're rated really well on Common Sense Media. These are all nice, they're a good first step for a vendor, but they're not enforceable. It's not an agreement. You cannot enforce them to abide by the pledge or anything else. That's why you need a DPA. So we have, through tech, we have now nearly 500 signed Massachusetts data privacy agreements. Some that might be of interest to you are on the screen, the computer science tools. Just because we have a signed DPA doesn't protect your district unless you sign on to the DPA. The terms and conditions in the DPA only apply to the participating districts that have signed on to the DPA. So if you see this list and go, oh, I can use Codable, you have to make sure your district has signed on to a Massachusetts DPA. And you can do that through us, through tech, or it's publicly available on the Student Data Privacy Consortium's website. You can do it yourself as well. So some vendors won't sign, and people want to know why they don't sign. The main reason is they don't comply with the terms of the DPA. They're selling or sharing student data to produce revenue for their company. They're using targeted advertising. They fail to meet the data security requirements. And it's interesting, nonprofits really fall into this category. We'll work with a nonprofit, like I'm trying to think of one offhand. And they'll look at our DPA and say, we don't have these data security requirements in place. So we can't use that application. Another reason they don't sign is they're a real small company. They only have 1 or 2 employees. They can't afford legal counsel, so they're not comfortable signing without a lawyer telling them it's okay. We totally understand that, but we won't use these applications. Our districts won't use them. Universities, by and large, won't sign. The only one I think we've had signed is Worcester Polytech has signed for assessments, but like MIT hasn't signed for Scratch or any of the other MIT apps that schools really want to use. So it's really important to remember, if you're using an app like Scratch, that you have to have a written parent permission for every child using Scratch. If you don't do that, you're in violation of FERPA. You're sharing that child's name or email address or whatever data the Scratch app is collecting without written parent permission. So you're in violation of FERPA. There is a way to use Scratch and some other tools without transferring any student PII. That's okay. As long as you're not transferring PII, personally identifiable information, you don't need a DPA. That's fine. It's when you want to give the vendor a student name, student birth date, student email, that's when the DPA comes into place, and that's when the FERPA laws come into place. You know, I thought I'd go back and just show you the consortium's website real quick. So this is a registry of tools that have been vetted for data privacy. So, and it's a public accessible database. You don't need a login. So let's say you want to see if Clever has signed a DPA. I just picked that. Search by resource. This is a national database, so it shows you all the states that are participating. So you can see here that Clever has signed the DPA, and all of these districts have signed on to it. All of these districts, their students are protected when they are using Clever. So you can also search by vendor. You can search by district. So you can come up and put in your district. So let's say you're from Arlington. You can see the DPAs that your particular district has signed on to. So they've done assessments and blooms, and you can search here. So you could put in Clever if they signed, and they did. This is a great database.
Is there any difference in you know, this is a thought that I always had about the DPAs and companies that sign. Are there modifications to the specific DPAs that like a district would need to worry about between applications? I know sometimes it takes a little bit of more longer time, and where's the line where it's a DPA that has like full coverage? Is there a line there that kind of becomes a tough crossing point for one of these companies that wants to sign and they're just not willing to give something up? Are all the DPAs essentially the same and exactly formatted the same in terms of the language?
So that is an excellent question. So you'll notice Clever was a vendor-specific DPA. So you see here, if it says tech agreement, that is the model DPA. It wasn't negotiated. It's just the model standard DPA. No changes were made to it. But if we go back to Clever, it's posted as vendor specific. And what that means is the vendor reviewed our DPA and they wanted to make changes to it. So they proposed specific changes to the DPA, which we had our attorney review. This particular DPA took about a year. Most recently, code.org did as well. they go back and forth arguing about language. I'm involved in these negotiations. I witness them. I don't do the actual negotiating. Our attorney does that. And a lot of times it's wordsmithing. Sometimes it just feels like these attorneys just need to prove their worth to their company, quite frankly, and they'll change an adjective here or there. We've had some real contentious negotiations. One was we're still in the middle of it actually, for New Hampshire. We've signed for Massachusetts. It's Class Dojo. They wanted to change the definition of targeted advertising. They wanted to be able to slip in some targeted ads to students. And in the end, there was no way we were going to agree to that. So that DPA took a long time to negotiate. I would say at least 70% of vendors sign the model DPA as is. It's usually the bigger companies that have full legal departments that do not, that request modifications, like Pearson, McGraw-Hill, some of those bigger ed tech companies. But if anyone ever wants to see the exact modifications that were made to a particular DPA, we can share, we have what we call a compare contrast document. So it shows in red every change that was made to the DPA. Our attorney is amazing. She's fabulous. She is a education expert attorney. She's licensed to practice in the states where we do our work, and she won't let vendors get away with a thing, but at the same time, she tries to understand their concerns. She tries to get to a signed DPA whenever she can, and she'll suggest different language that we might be able to accept if we can't accept what they've proposed. So we're really fortunate to have her. We pay her a great deal of money, and she's worth every cent. And the vendors do appreciate her style and her expertise. I think they really do respect and like working with her.
You got me thinking about a couple other topics too. Would you mind, just for the sake of someone who might be new to data privacy, and how do you define PII, and what is the difference in other, maybe a vendor's definition of PII, and what should maybe a teacher know of what, the danger of sharing too much PII, personally identifiable information?
Okay, and that's it. I can actually bring up the definition here. It should be in here somewhere. This is an actual DPA, so we can just go to the definition section. But like you said, PII stands for personally identifiable information. And under the law, even a child's first name is considered PII, even just their email address. And under FERPA, I think a lot of districts try to get around this by using nicknames like Batman or Student One, or under FERPA, that still creates a student record. So it's not a workaround. It's not a way around the law. So if a good rule of thumb is, if your students have to create an account, then you need a DPA. If the teacher creates an account, you might not need a DPA unless the teacher's doing student rostering or providing other student information. So I like to think of it like this. If someone just walked into your school off the street, you would never give them your class list or your students' email addresses or their date of birth. So it's kind of like, and I was telling Dan at one point, we're really coming out of the wild, wild west, where the emphasis was on teachers to go out and find great apps to use in their classroom. And they did, and they found great apps, but there was no real vetting process around privacy. There certainly was around education and technology. But so now we really have to worry about privacy. So if you are giving student data to some company online, you have no idea if it's safe or not. You have no idea if they're treating the information the way the law says they have to treat it. So, and I see a lot of requests for me to get data privacy agreements with companies that are located in Taiwan or China or, you know, some other countries that have totally different laws and may not look at student data the same way we do. It's a little scary. So you really want to be careful. So that's why this whole process works. We do all the work. We find out if they'll sign a DPA. If they sign, you're good. You know you can use that app. You know that the student data is protected. If they won't sign, you can look at the data privacy policy on the vendor's website. You can read their TOS. You can see if you think they're a good company. And if you do, and you still really want to use that application, you need to get written parent permission to protect your district and protect you. So we recommend you don't use an app that has declined to sign a DPA unless you can do so without transferring any PII. But we realize that some apps are just mission critical and you really want to use them. So that's why we provide a parent sign-off document that our attorneys drawn up.
Would you mind just flipping back on your presentation to the list of computer science apps? Maybe we could, Kathy, do you want to like chime in on some of these apps that are approved, and maybe we could talk about the unapproved ones as well? And
well, my question was, how would we, one of my quick questions was, how would we get a hold of this document for apps? Like, I'll be honest, most of the apps that I've used in the past, such as, of course, Scratch, but also as you were talking, Rayma, I started to think about MIT's App Inventor, which we've used.
Yes, you need parent permission to use App Inventor. Everybody loves App Inventor. It's a great app. Just get parent permission and you'll be fine.
How do we get a hold of your permission document that your lawyer drew up? Or do we just make up one? I mean, do we use yours?
So no, Dan, you have it, don't you? So
we have access to that. Yep.
Oh, okay.
So we provide it to all the districts that join tech. And I think we have a couple hundred districts that have joined us. We provide a lot of services, like the permission slip form.
Would it be the same for something like a Chrome extension, say, that a teacher developed? I see, you know, we've just gotten off this whole thing of remote learning and teachers were requesting things left and right. And some of them were things that only the teacher was using, such as a Chrome extension that would convert a spreadsheet into a Google Doc that the teacher could read more easily, something like that.
So if the vendor, if that Google extension is not receiving any student PII, you don't need to worry about this.
Okay, good. Okay.
But I would say it's worth asking because some of them are so, you know, synced with Google that we know there's a Gmail involved. So it's whether or not they're hosting that Gmail information, correct?
Yes.
Yeah.
Right.
And so that's the way I kind of keep it in my mind when I'm looking at, but I don't know. I mean, because, you know, it's inside Chrome and Chrome holds personal information as well. The Gmail holds personal information. So, you know, I don't like to take it, you know, and tell me if I'm, you know, wrong. I don't like to take it on word of the vendor sometimes. Is that sometimes all you have to kind of go by, though, is the word of the vendor that they're not getting
yes
in the way they've written the app?
So we'll send them the DPA and they'll push back and say it's not applicable to us. We don't receive any student PII. At that point, it really takes a district to kind of tear it down and look to see if it is, if there's any way that PII is being transferred.
Yeah, the Google Meet extensions essentially operated all that way, where you know, they were all, you know, each one said that they weren't collecting any information.
Right. We are doing something new. So the consortium's been working on a national DPA, one document for each state and that for the whole country, one document. And then each state will have an addendum that has their unique state laws on it. We're really excited about this. And what we did is we put in some terms and conditions there that for vendors that say they don't collect any PII, we're going to ask them to sign it to attest that they do not collect any PII, and that they'll notify us if that ever changes. We'll see how this goes. I have no idea if we can get anybody to sign it, but we want to take it that next step, make them contractually say we don't collect PII, rather than just an email to me saying we don't collect PII. So we're hoping that national DPA will be out this fall.
Oh, okay. So that'll be kind of a game changer, because
Yeah.
then we'll definitely get more of a national view of which, you know, they won't see it as a state by state process anymore.
So they'll see it as both. So the beauty is the bulk of the document is like 20 pages, and that's the national part, and it's good for every state. So a vendor only has to review those 20 pages once, and they know they can sign it. So as each state approaches them, they'll approach them with a one-page addendum with their unique state laws. So it's a lot less work for vendors.
It's just a smart step.
Yeah.
Kathy, do you want to just look at this app list and talk about some of these apps that you've used before and just what their best use is for computer science? I mean, I know Coded.org recently signed as an approved tool. CodeHS we've seen used in the high school.
We've used CodeHS in the high school, yeah, so that's a relief.
Do you want to add some details to some of these other ones in case people aren't familiar with them?
I'm trying to think. Oh, wait a minute, hold on, sorry. Hold on.
Code's an up and coming popular app. We've explored that for kind of block-based programming, you know, and it has some great expandability. Coders we've used for virtual robotics.
Right.
Real, you know, and hands-on robotics. They're based out of New Hampshire.
New Hampshire, right. I know we've used Tinker in the elementaries. We've used Tinker.
What's that about Tinker?
I said we use Tinker in the elementary, so that's nice that they've signed.
That is nice that they've signed, because are they using that with 3D printing?
Yep.
Yeah.
Yep.
And that's one that was the main app used for specific applications and maker spaces.
Right.
Code.org every year for our code, you know, you're using generally Code.org resources, and you're asking kids to sign into Code.org. So it's great to see.
Right.
You know, it was kind of like an odd feeling last year. You know, how do you do our code without using Code.org resources? And you know, the kids all want to log in, and they want to be able to save their work, and they want to be able to use the application.
I've got to nip out for 2 seconds. I'll be right back.
Sure.
Okay. Sorry.
Yeah. So it's great to see in Spiro. Spiro is very popular in, you know, elementary with the Spiro device. So this is a pretty good list. I would say this has grown a lot since last year. I would say half of these at least were not on this list last year. And I know in my own computer science department, we look, you know, we asked about Tinker, Codable, Code, Combat, CodeHS, all within the last year. So those are ones that I know we've been using, you know, between elementary and high school. So it's good to be able to get these started and, you know, have an actual list of tools that that computer science teachers can use. And I also know that often the computer science teachers sometimes teaching in isolation in their building. So it can kind of be hard to necessarily have someone to speak to about what resources they should be reaching out to kind of see are approved when you're thinking of data privacy. So I appreciate you, Rama, putting these on here, and so we can talk about them. So I had a couple other few questions here. you know, I think we've had the experience of an app that is free, not signing when not signing, but when you pay, like I'm thinking of Zern, and I'm thinking of, we've talked before about apps that it isn't until you pay that they actually are able to, are willing to sign off on the agreement. Would you be willing to speak to a little bit about that?
Sure. The main reason for that is their free product includes targeted advertising. Their paid product does not, so they can't sign the DPA for the free product.
Now, does that
it's
differ
free.
if does that differ if they're not accepting? I mean, I guess if they're not accepting any personal identifiable information, they don't need to sign anyway. So that would be kind of a separation. So I was just sorry. Yeah, because I've come across a couple that, when you pay, they're willing to, do you see any changes in that coming down the line, or anyone calling apps out for that? Or, because basically their free version is basically what they're using to kind of get people to buy into the product.
Right. We have seen some movement where people have refused to sign for the free at one point and then changed their minds. I think it's because they have enough of a revenue stream, and now they can turn the targeted advertising off for the free product. But as we were talking before, nothing is free. When it's free, the student is what's producing the revenue for the company, either through ads or usage, one way or another. Research, data, right.
Exactly.
So
what do you see coming down the path? I've used the Learn platform before to help establish some, kind of district ground rules for data privacy in terms of statuses, whether something's approved, unapproved, or it doesn't collect personally identifiable information. What do you think is going to be some kind of next steps coming down the road for districts that are kind of, are adapted to signing DPAs? And what do you see as the next step in terms of organizing their essential list of apps? I mean, the website's great, but it's also a very fluid process on the school side. So what do you see is happening in the near future?
Well, I know the consortium is super excited about, and I'm really not the person to talk about it because it's highly technical and I'm not a technical person, but the consortium is really excited about, they call it pods. So if you are using that database, you can send a pod to the vendor with the exact data security requirements required, and it goes to the vendor. And so then the vendor knows exactly the data security requirements to put in place for that district.
Wow.
Yeah. So Steve Smith's very excited about this. That and the national DPA are the two real big things for us this year.
So do you think maybe those might become like something that's like, almost like a law, that specific groups of data sets become something that can be protected?
It could be. The consortium's also, not the consortium itself, but alliances of the consortium are working with this governance group to try and get federal laws enacted that don't allow vendors to do some of the things they're doing. So we should hopefully see something come out of that in the coming months, years.
Yeah, it's going to be, it's shifting. Things are shifting pretty quickly. I feel like every year there's new stuff coming down the pike. We talked about why some apps don't sign. There's an interesting thing that happened. This consortium, all the state alliances, has become just such a great organization. Adobe would never sign our DPAs. They said they were a general market product. They wouldn't be a school official. So for years, we've not had a DPA for Adobe. So just last week, we had several state alliances, Massachusetts, me,
Steve Smith, New Hampshire, Utah, California, Texas. We all got on the phone with about 5 people from Adobe and said, we showed them how Adobe is posted on the consortium's database where it says not approved, not approved, not approved. And we really got their attention. And I think they're going to sign the national DPA as soon as it becomes available.
Wow, that's great.
It is. You do hear vendors push back a lot and say, I don't want to sign 50 different DPAs with 50 different states. I think that's kind of a lame kind of excuse, but that's how, so we are making inroads with Adobe, but I don't believe that any one of our states could have accomplished that alone. It's the group, the power of the consortium, all of us on the phone saying the same thing. Our schools aren't going to use Adobe unless you sign this.
Now I have a question about Clever. Clever has, a 2 authorization sync. It provides single sign-on for apps that, have signed a data privacy project. Some of them may not, and some districts signed off on privacy, or it may just take you directly to a website. Now, through a third party, does an app like Clever protect student data, or does the reliance on the Gmail being the sync, is that sync blind, or is that, do you know if that helps protect data at all?
So I've asked this question. I've asked Steve Smith, if you're doing single sign-on with Clever, do you need a DPA with the back-end app? And the answer is yes. He doesn't trust that none of that data is getting through Clever to the next vendor.
Because Clever says that, Clever is kind of, when you talk about Clever, it's, they're saying they're using, authorization that does protect the other side. So it's kind of, you're always kind of curious, but they still have to provide some sort of information to sync. So
right.
You're wondering how the sync works, whether or not, the authorization codes are blind. So I'm, just figured I wondered if you knew anything about that. So
we're just being really careful. So we'll still get the DPA with whoever you're signing on to.
Because on that level, those data is so different on that level. It's, it could be a lot, it could be 300 digits long, it could just be, an authorization code. So do we want to talk a little bit about Flipgrid? And what
yes.
the experience with, because Flipgrid has not signed a data privacy policy, and people love Flipgrid.
We're close. We're so close. So Flipgrid is a Microsoft product. Negotiations have involved Microsoft lawyers, Flipgrid lawyers, outside counsel, and then our attorney and me. It's been a long road. It took us a long time to get them to come to the table. We started our negotiations, and Wayland Public Schools was the originating district. And through the negotiations, we learned that Flipgrid's very different from other products in that when you want the data deleted, you can't go to Flipgrid and say, okay, our seniors have graduated this year, delete all the data for our senior class. You have to do it through a teacher account yourself on Flipgrid.
Okay.
So the Wayland Public Schools was not willing to manage that. They didn't want to take that on. They saw that as, being difficult. How many teachers' accounts would they have? So we found another district. The Westwood Public Schools stepped up and said they would be the originating district. So they're getting near the end of negotiations, and being from Massachusetts, this won't concern you, but Flipgrid said they would only sign with Massachusetts. They would not sign with New Hampshire and Rhode Island, and we're charged with caring about all 3 states. So our attorney took all 3 DPAs and merged them into one document and said, okay, will you sign this? And they're going to. They're just, when they get to the very end, it's like those little tiny adjectives and things that they're arguing about now, but it feels really solid. It feels really good. It did not a month ago or 2 months ago, but it's feeling really, really promising now.
From what I remember, there was like no traction.
Yeah.
And then I remember the email coming out with Flipgrid asking, remember you sharing with me and a couple other tech directors, would this be okay? And it was essentially handing the sharing privileges over to a teacher. And to me that, that wasn't okay because, you can't, there's no guarantee around what anyone, a teacher or anyone might do with access to the student data from a share. And once it's out there, you're never going to pull it back. So,
Well, I think what Westwood's plan is to have one teacher account, just one. And have, I don't know if the technology director, I don't know who's going to manage that account, but that was how they saw it. Of all the apps, the pressure to get something signed with Flipgrid was the biggest from districts. The districts were actually emailing Flipgrid going, sign our DPA. They just really want to be able to use Flipgrid. Wayland ended up going with a new product out by Screencastify or something like that. Are you familiar with it? Screencastify.
Screencastify?
Yeah, a new product.
They signed pretty quickly. Screencastify signed on pretty quickly.
Yeah, they're good.
And they're in partnership on an app with Edpuzzle.
Yes.
Okay.
Edpuzzle was great to work with too.
Oh, good to know.
I know is waiting because I was just getting pricing from Edpuzzle. Edpuzzle is waiting. Edpuzzle won't. Edpuzzle I think is the lead app on that deal, and Screencastify is kind of basically following along with what some of the other apps that they've already partnered with on. That's what it feels like, because I know that they want to be able to be bundled with the purchases. So, I mean, people love Screencastify. It was a big, very popular app during remote learning. So,
Right, because of remote learning, exactly. But Flipgrid is pushed by a lot of ed tech, gurus who I get a lot of emails from. And just today I got another one on Flipgrid, promoting Flipgrid to use.
How about applications that are software or program that are installed on specific Windows machines? Like, for example, like Screencastify. If a teacher installs Screencastify, Screencast-O-Matic.
Screencast-O-Matic, yeah.
A specific install off the web for their free version. Now, we're not necessarily advising students to use Screencast-O-Matic, but a teacher who is, not, sharing a Gmail, using their own specific information. Is there any advice or suggestions around applications that installed as opposed to some of the web-based applications that are, really popular with creating portals?
So if it's installed, are you still transferring PII to the vendor?
Well, you would be, a teacher may use their username.
So as long as there's no student data going to the vendor, you don't need to worry about a DPA.
Okay.
At some point, I think we're going to be worried about staff PII. We should be.
And right now, what I've been giving as advice on that is I'd say, if it's in the right mind of the student, it's also in the right mind of the teacher.
Right.
It's all in the same place. I don't think they're, these companies aren't necessarily different between student and teacher data. To them, it's probably just one name.
So New Hampshire law does protect staff data. Everything but their name and email address. So if you think about your SIS, it's got a lot of staff data in there.
Yes.
So I think all the states will move to that eventually.
Yeah, eventually, because it's good ethics, right, to protect the staff as much as the students, especially within an organizational account.
Yeah.
How about with one-to-one tools? Some of the, I talked with a company today, One-to-One Manager, and they said that we had asked them about data privacy because this is a tool that helps manage one-to-one rollouts and device breakage, and it syncs with the SIS. And
is this from Learn 21?
Yes. So they said that they were.
How well you knew.
And I was just wondering if you had any feedback on that.
So, yes. So it's a small world. So Learn 21 is in Ohio.
Yep.
And
nonprofit.
Yeah, but it's also my counterpoint of the Ohio Alliance. It'd be like if I came up, yeah. So he's looking for a Massachusetts district to use one-to-one, so that he can sign the DPA.
I think Boston is taking it on, and I'm very interested in it. So
yeah.
Sorry.
I believe Mansfield is going to sign as the originating district. Yeah.
So yeah, because there's a whole lot of sinking going on there.
Yeah.
And that was kind of our question. We kind of burdened. He has this great little young sales rep that I think we kind of burdened with the question. But he had heard of the mass data privacy DPA. So
it's Bill and Josh Fritz, right? Bill and Josh. I think Josh is his son. Yeah.
So, and it was interesting because it's a nonprofit, and essentially he's a tech director, right, in Ohio, and then his son is in Kentucky. If that's his son. So it was an interesting. So we're close to that one, I guess. Then.
Yeah. He'll sign it. He just needs an originating district.
Gotcha. Okay. So, I mean, I guess for a teacher, what should they be thinking about with student data? I know you've kind of answered this question in a lot of different ways, and maybe as a couple final words, with student data, a teacher who maybe their district hasn't necessarily signed on yet, or they don't know enough about the process yet, and maybe they're just getting started. What are some ground rules for an educator, just to think about with student data privacy as they kind of get started?
So I would say the way a teacher keeps children safe on a field trip, at recess, outside in the classroom, all the things that a teacher does to keep children safe, you have to apply that to their presence online. There's so many high-risk things out there that these students can run into if they're not protected. So I think it's just a new mindset that teachers have to get into, that if they're online, they're vulnerable and we have to keep them safe. I think most districts have a process where a teacher identifies an application they want to use. It's vetted to make sure it's educationally aligned. And then perhaps does it work within our technology? And then the third is, will they sign the DPA? And if all those three things is yes, then the teacher gets the green light to go ahead and purchase that app or download a free app or whatever it might be. But, and I would also say too, what I see a lot is we must have 30 different typing apps approved. and you wonder why everybody's using different ones. And some of them are from foreign countries, and I just worry about their laws. They've signed the DPA, but you just wonder, how enforceable is it? If there is a breach or something, how am I going to enforce this DPA with this company in China? Am I going to take a report in Suffolk County or, So I would just say, try to use well-established, vetted apps. Absolutely, everybody wants to go out there and look at new things, but be careful. Make sure they'll sign a DPA before you start using it in the classroom. Just really think about it as you're putting the kids at risk when they're out there online. So you need the safety mechanisms in place to keep them safe.
Yeah, check with your tech director and see if you're part of this. And I would say we, in my experience, and I don't know if Kathy would add to this or not, but I've learned a lot more by just being patient in the vetting process. And, there's been apps that have gotten approved very quickly, but then we realized there was something else about them. Genially was one.
That was supposed to be our replacement for Canva.
ThingLink too. We were looking as a
ThingLink
replacement, but I think ThingLink signed, right? ThingLink.
Yeah,
signed.
They did sign, but I didn't enjoy that interaction with them. Let's just leave it at that.
Wow.
We were using ThingLink quite a bit prior to getting involved with data privacy, and then we essentially kind of, we had a couple teachers who retired who stopped using it. It was a kind of a good break off point, and then people were asking, when, can I use ThingLink? Can I use ThingLink? And we said, no, we're vetting some other apps. And Genially came along, and Genially, like when I tested the app, looked like, oh, this is this great tool that basically does a lot of the same things as
Yeah, very much like Canva. Yeah.
Yep, and it was very graphical. And then
Mhm.
I created my own account to test it. I got using it. We got it signed off for privacy. Library media specialist started, practicing her lesson with it.
Mhm.
And then we realized that a student could create a graphic in Genially that could include anything. Their name, their picture, any piece of information, and share to the world.
Mhm.
And at that point it was like, this is not a good solution, because they were, at that point it's not so much around the student's identification, but if a student put important information on their schoolwork, their photo, and had the only option was to share that publicly, that's kind of a red flag. And it reminded me of a story where we had a library media specialist say she had once had a project where a student, she was looking at some projects of someone online who had essentially shared their entire life story within like a Google Slides presentation. It's like, sometimes I think even if an app signs, you still have to look at how it's used.
Yeah, absolutely.
Protecting, they might be taking a shortcut to sign the policy, but not necessarily thinking about how the app might realistically be used by like a middle school student in terms of sharing.
It's very true.
And that's the thing, is like, nothing's better than just vetting something, even beyond the privacy too, and making sure that it fits your needs. And it can be frustrating, asking for 5 apps and only knowing maybe one might come back approved too, and it being
True. True.
Too. So no, and so Ram, I appreciate your time. This has been great. So, we share a lot of emails, and I know I'm behind on my contracts, as reminders. But I appreciate the time you spent, today, and thank you, Kathy, also. And we'll share this with as many computer science teachers as we can to kind of get them to kind of understand the importance of data privacy and the why.
Right. I think if we show this to the other digital learning specialists, it really is an eye opener. I know it's been that way for me. And now I'm thinking, life was so simple when you just installed Scratch and no sign in with the old version. Life was so simple.
Go back to that.
We still have it in some of the elementaries, the installed version. Yes. Yeah.
So it's, and our labs are run by Chromebooks and other things that,
Right. Right.
So thank you very much. And maybe we can connect on some more topics in the future. That'd be great.
Absolutely. It was a pleasure. Thank you. I enjoyed it.
Thank you, Rayma. Thank you.
Bye-bye.
Okay, bye-bye.